You could just read that clearly. Any potential co-conspirators, that's Maxwell, including but not limited to these 4 women plus Maxwell. Like, she's clearly included in that, but they're going to say she's not. Now, it's well established in our circuit that a plea agreement binds only the office of the U.S. attorney for the district in which the plea is entered, unless it affirmatively appears that the agreement contemplates a broader restriction. Oh, so they're just saying it's limited to Florida. Ghislaine Maxwell, Jeffrey Epstein's number 2, got some bad news from the United States Court of Appeals for the Second Circuit. She took this case up on appeal from the Southern District of New York. This is where she was convicted of multiple crimes for being involved in Epstein's ring. But what was so curious about this is we were wondering why she was prosecuted at all, because Jeffrey Epstein had a very, very nice non-prosecution agreement that covered Ghislaine Maxwell. Covered, I think, everybody that Epstein ever talked to, essentially. But Ghislaine said, wait a minute, why am I being prosecuted? Why are all the people who used Epstein's services and Maxwell's services, why are they not in custody with me? Why are they all out running free, trying to make us take vaccines and not facing any repercussions at all? So Ghislaine took this up. The Court of Appeals is telling her, you're done. Sorry, not good enough. Ghislaine Maxwell, writes the Court of Appeals, now appeals her June 29th judgment of a conviction that came out of the Southern District. Maxwell was convicted of conspiracy to transport minors with intent to engage in criminal activity, transportation of minors, sex trafficking of minors, and so on. But who did she traffic them to? Apparently nobody. She was principally sentenced to concurrent terms of imprisonment, 60 months, 120 months, and 240 months respectively, to be followed by concurrent terms of supervised release, meaning these are all running at the same time. You don't do 60 months and then 120 months and then 240 months. That would be consecutive, but this is concurrent, meaning they're running parallel with each other. So Ghislaine is appealing this. She says, wait a minute, hold on. She said Jeffrey Epstein's non-prosecution agreement with the DOJ prevented Maxwell from being prosecuted because it immunized her. There was a second superseding indictment. They said that did not comply with the statute of limitations. They say the lower level court abused her right to a fair trial motion, and the response to a jury note was also problematic, and her sentence was procedurally reasonable. So the Court of Appeals says, no, it was great. Finding no errors, we now affirm Ghislaine Maxwell, you're going to continue to sit in custody and you're going to be there for quite some time. Here's what the Court of Appeals says, that Maxwell appeals all of this. She was engaged in a conspiracy, and on appeal, the question is, does Jeffrey Epstein's non-prosecution agreement, his sweetheart deal that was entered into by Florida, does it protect Ghislaine Maxwell as well? They hold that Epstein's NPA, the non-prosecution agreement, does not bar Maxwell, and it does not bind the Southern District of New York. They say the indictment complied with the statute of limitations and other things. In September 2007, remember this, following multiple investigations, Epstein took his first plea deal in Florida. Epstein agreed to plead guilty to 1 count of solicitation of prostitution in violation of Florida statutes. It was a joke. It's a state level crime for solicitation, which is like asking for. Violation. He agreed to receive a sentence of 18 months imprisonment, and the non-prosecution agreement, right, this sentence was a wild one. It said the United States also agrees that it will not institute any criminal charges against any potential co-conspirators of Epstein, including but not limited to these 4 women: Sarah Kellen, Adriana Ross, Leslie Groff, and Nadia Marcinkova. Insane that this would be so broad. You could just read that clearly. Any potential co-conspirators, that's Maxwell, including but not limited to these 4 women plus Maxwell. Like, she's clearly included in that, but they're going to say she's not. Now, the indictment filed against Maxwell contained 8 counts, 6 of which proceeded to trial. Prior to the trial, prospective jurors completed the questionnaire and voir dire was completed. They impaneled the jury. 4.5-week jury trial. We covered it. It was insane. Following the verdict, Juror 50 gave press interviews, and Juror 50 even admitted after that Juror 50 was a survivor of child abuse. In his answers to the jury, he said no. He said, no, I'm not a victim of child abuse. Then he is. He's like, I got abused, so I know how this works when he's on the jury panel. He answered, he basically lied. He was wrong on the jury form. Maxwell moved for a new trial. She was sentenced to 240 months, big fine, and more. Now, here's where they get into the details. Now, Maxwell sought a dismissal. She says, I'm covered by the non-prosecution agreement. In arguing that it barred her prosecution, she cites a portion of the prosecution where it said it would not institute any criminal charges against any co-conspirators. Now, it's well established in our circuit that a plea agreement binds only the office of the U.S. Attorney for the district in which the plea is entered unless it affirmatively appears that the agreement contemplates a broader restriction. Oh, so they're just saying it's limited to Florida. What a cop, man. That's funny. So it's only limited to Florida. So Ghislaine is only immunized if she's prosecuted in Florida. What a joke. And while Maxwell contends that we cannot apply an abi to an agreement negotiated outside of this circuit, we've done this before. And so we conclude that Epstein's deal did not bar Maxwell's prosecution in New York. This is a lot less interesting than I thought. There is nothing in this that shows that it was intended to bind multiple districts. So they didn't say that it should bind her in New York. Instead, where it's not silent, the agreement scope is expressly limited, they say, to the Southern District of Florida. They make it clear that if Epstein, he would no longer face charges in that district if Epstein did his job. So they write here, in this district, no charges in this district. So they can charge him elsewhere. Whatever. The only language that speaks to the agreement scope is this limiting language. Now, the negotiation history, just as the text, fails to show that the agreement intended to bind other districts. And so our precedent says that the NPA, unless it specifically affirmatively binds other districts, it's not bound. So they say the U.S. Attorney's manual that was operable during this required that, right? So our own manual also explains. And so her conviction is valid. And so this case controls. Nothing in the text suggests that New York couldn't prosecute him. Only Florida could. You know how many different jurisdictions there are? What good is an immunity agreement, a non-prosecution agreement, if they can just go next door and charge you? And they knew this, okay? It's a joke. All of those 4 women, Epstein was traveling around everywhere. He was in New York. He was in New Mexico. That was contemplated to give him total immunity from everything. And then they just indicted him elsewhere. Maxwell too. It's a joke. They're scapegoats, okay? This is a cover-up, and it irritates me that more and more people are not indicted as a result of this. And they're just going to cover it up. Oh, she did it. Her convictions will stay, and we're just going to button this whole thing up. So now they're talking about the statute of limitations, and their denial of her request for a new trial was absolutely proper. So we review this for a new trial, did not abuse their discretion, and the juror's testimony was credible. That his error during voir dire, when he was actually abused of sexual abuse, it was not deliberately incorrect. So it was an innocent error. And even if he would have told us the truth, he would not have been struck for cause if it was accurate. And so it didn't ultimately harm Ghislaine Maxwell, and the court did not abuse its discretion in denying the motion. And I think the judge who presided over this case actually got an appointment to the Second Circuit. And so they sent out the following note as well. Under count 4, if Maxwell aided in the transportation of Jane's return flight, but not the flight to New Mexico, can she be found guilty under the second element? And so they referred the jury to the count. Maxwell filed a letter seeking reconsideration, and the court is going to deny that as well. And so we agree with the district court that the jury instructions, while the note could have been ambiguous, it was clear it referred to the second element of count 4. And so we cannot conclude that the evidence prejudicially varied from the indictment. And so for the reasons set forth above, all this is valid. And Ghislaine Maxwell's sentence remains. So they summarize for us as follows. They write, the district court did not make a mistake in holding that Epstein's NPA did not bar Maxwell's prosecution. So it was blanket immunity only for Florida. The district court did not err in holding the indictment was filed within the statute of limitations, did not abuse its discretion. And so Ghislaine Maxwell now is going to be held in custody and serve out the rest of her sentence unless she appeals this. And she will. She'll appeal this up to the Supreme Court. Now, I don't know if the Supreme Court's going to reverse that, but what they did is a cop here. They gave Epstein basically blanket immunity and let him run free for a long time and then reverse that. Maxwell is the scapegoat. Everybody else who was responsible for their services escaped prosecution. Very, very convenient.